Hello and welcome to this webinar on vendor due diligence under the GDPR. My name is Georgina Lawrence. I'm a Senior Associate in Fieldfisher's Privacy, Security and Information Law team in London. I'm joined by Alex Beresford, a solicitor in the same team. This session is the fourth part of our Get Data Protection Fit programme. The plan was to provide videos to cover different levels, from the fundamentals to applying data protection law in practice. We've already completed Module 1 and the other parts of this Module 2, and they are available to view on Fieldfisher Privacy and Security Information Law's YouTube account. In this session, we're going to look at how to undertake due diligence on vendors or suppliers, and we'll refer to them as vendors throughout. Due diligence is a detailed and complex area. The aim of this session is to give you a good overview in terms of recognising various vendor relationships, explaining the importance of due diligence, and explaining how to carry out due diligence and how to evidence sufficient guarantees.
Thanks, Georgina. Now, it's important to put into context why the contents of this session is so important. We're not trying to scare you, but not complying with this obligation can and has led to significant fines where a controller has failed to do sufficient or continual due diligence on vendors. And as we mentioned in a previous session, these fines can be up to 10 million euros or 2% of worldwide turnover, depending on which is greater. Just as a reminder, these obligations we're talking about today apply to pre-existing contracts entered into before GDPR, so it's no good just putting a process in place today. You'll need to go back and review the contracts you already have in place. Let's turn now to look at the various vendor relationships. In a previous session, we discussed the difference between controller and processor. As a quick reminder, a controller makes the decisions in relation to processing of data, and a processor complies with the controller's instructions. Feel free to look back on a previous session if you need more of a reminder. Now on the slide, you will see a diagram setting out a controller-to-controller relationship. Whilst the GDPR does not explicitly require due diligence for these relationships, GDPR principles and commercial considerations mean it is still essential. For example, if you are a controller and you are sharing user data with another controller, you've got to be satisfied that the third party is reputable and will use the data for limited specified purposes only, or you may be in breach of the core GDPR principles. And if you're a controller receiving personal data from another controller, you'll need to check that the data was obtained lawfully and can lawfully be disclosed to you. The focus of today's session will mainly be on the controller to processor relationship, which you can see on the left-hand side of this slide. We will mainly be focusing on due diligence from a controller's perspective, but we will also touch on the vendor's perspective as well. And on the right-hand side of the slide, you will see a diagram setting out a processor to sub-processor relationship. Remember that the due diligence obligation also applies to processors when they engage sub-processors. If you have listened to our previous session on Article 28, this slide will look familiar to you. Whilst the previous session focused on the middle box, putting a GDPR-compliant data processing agreement in place, the focus of today's session is the boxes either side, the prior due diligence and the ongoing checks. Hopefully, you're starting to see how this all fits together.
Thanks, Alex. So where does the due diligence obligation come from? Well, Article 28(1) of the GDPR specifies that controllers should only use processes providing sufficient guarantees to implement appropriate technical and organisational measures and ensure the protection of the rights of the data subject. So this applies to controllers engaging a processor and also processors that were engaging sub-processors. So what must be conducted is the minimum due diligence checks for the controller or the processor to satisfy themselves that the processor or sub-processor, as applicable, can provide sufficient guarantees to ensure the processing will meet the requirements of the GDPR and not just the security requirements. The GDPR includes recitals, and these provide additional detail and context. Recital 81 adds further clarification on what sufficient guarantees would look like. So this would mean that the processor or sub-processor should be able to demonstrate expert knowledge, reliability and resources which allow them to implement appropriate technical and organisational measures, including for the security of processing. Due diligence should include both pre-contractual checks and audits during the contract terms, and we'll consider how this might look in practice shortly. So how do you evidence sufficient guarantees? Well, as we've seen, the GDPR does not specify what checks must be carried out in order for a controller to satisfy itself of sufficient guarantees. So there are various methods or stages where this can be addressed by a controller. The tender process. When setting this up, build in the expectation that vendors will be able to evidence good privacy practices and establish that this is a part of the criteria for selecting a vendor. Use any interviews or pitches to ask further questions around this. Require a vendor to complete a due diligence questionnaire. Note that some vendors may refuse to complete such a questionnaire and instead refer customers to GDPR FAQs, which set out their GDPR compliance efforts for customers. If they do complete a due diligence questionnaire, review the responses and document evidence that you are satisfied that the vendor can provide sufficient guarantees by making an internal record. Vendors that do not understand due diligence questionnaires or do not know how to answer the questions may not be very sophisticated in privacy or not familiar with the GDPR requirements, and this demonstrates a potential risk. We come on to consider due diligence as part of a merger or acquisition in a later session. In terms of ongoing checks, regularly review the responses to the due diligence questionnaire to check that the guarantees provided are still upheld by the vendor and make a record of this check. Also use your audit right. That should be set out in detail in the data processing agreement or clauses, and we'll go on to this in a bit more detail later.
Thanks, Georgina. So we've now considered the different methods for evidencing sufficient guarantees, but we do understand it can be hard to know where to start and what level of due diligence needs to be carried out. This will depend on a number of factors. So looking at the slides, working our way around clockwise, we need to consider whether the service being provided by the supplier or vendor involves a new processing activity. Or does it involve new types of data? Do you need to carry out a DPIA? That's a data processing impact assessment, and we cover those in more detail in a later session. The DPIA is a way of assessing the privacy impact of the processing. Can the vendor help with this DPIA? Is the supplier a processor or controller? Is the supplier a group company? The more you know, the more you can limit the due diligence process. Where is the supplier located? This will help identify whether you need to ask questions around data transfer mechanisms. Have you used the supplier previously? If they are an existing supplier, or you've used them recently, the due diligence you carry out does not need to be as extensive, but you'll still need to make sure you can evidence the sufficient guarantees based on this new type of processing you have in mind. Essentially, these factors are all to understand the nature of processing and to identify possible risks when outsourcing to a particular vendor. It's unlikely to be the same for every type of vendor, but proportionality is key. The higher risk the processing, the greater the checks you should undertake from both a GDPR and commercial perspective. As a controller, you could consider developing a checklist of indicators for assessing this risk. For example, you could put in this checklist questions such as whether the vendor is processing a high volume of personal data, whether there's special category data, whether the contract is lengthy, and how important the personal data is to the product and services you're looking to outsource. Let's look for a moment specifically at the Due Diligence Questionnaire. The ultimate aim of this questionnaire is to work out where the risk lies and to ensure that there are no big surprises when the vendor provides the product or service. Each organisation's due diligence questionnaire will be different, but the sorts of questions you'll be looking to ask are, for example, what security measures does the vendor take to ensure the security and confidentiality of the personal data? How will they hold the data? Will it be separate from customer data, for example? And where is the supplier located? In which country will the data be stored and accessed from? Do they intend to use any third-party processors? And where are these third-party processors located? What measures does the supplier have in place to train staff to ensure the reliability when handling personal data? What procedures do they have in place to ensure that all data is kept accurate and up to date? Do they have procedures in place for notifying any security incidents or suspected incidents to the controller and for assisting with any reporting obligations that follow? Do they have any procedures in place to notify the controller of data subject requests and to assist you with the response obligations? We would definitely suggest that the controller prepare a template questionnaire and possibly even a couple of different template questionnaires to reflect different vendors. Perhaps you could have a template for those vendors with high, medium, and low risk. Now, if you have listened to the other webinars in this series, you will know that we have already considered the requirements of a data processing agreement in a previous session. Remember that Article 28 GDPR terms need to be put in place to set out exactly how a supplier will comply with its processor obligations and how it will help the controller with its own obligations under GDPR. You can also use the agreement to assist with the evidencing of sufficient guarantees. Many organisations add an annex to the agreement which describes the processing, so this will set out the data subjects, the categories of data, and the processing operations. You can also consider whether you would want to add a list of minimum security measures in a security schedule or a list of any approved subcontractors.
Thanks, Alex. So we've referred throughout this session to ongoing due diligence. What does this look like? So accountability. This is a key GDPR term, and it's around recording your processing activities. So make a record and maintain evidence of your due diligence. We looked at accountability in a previous session if you'd like more detail on this. Regularly review the initial due diligence that was carried out to check that the vendor is still providing guarantees as promised. In addition, the GDPR provides a right for controllers to audit processes, so use this right as it helps to establish continued sufficient guarantees. So throughout this session, we focus mainly on how due diligence would look from a controller's perspective. Looking at it now from a vendor's perspective, a vendor that is keen to be instructed by a controller, they need to consider what they should put in place to deal with the due diligence questions that they're likely to receive from the controller. So in terms of preparation, A vendor could ensure that they have adequate security measures in place. Make sure that they undertake due diligence with sub-processors. Be prepared to answer the typical types of due diligence questions. Keep records of the processing and be prepared for audits from controllers throughout the contractual relationship. So key takeaways from this session. Take a proportionate and risk-based approach. This will depend on the type of vendor and the type of processing. Put a due diligence process in place to ensure that this is an efficient process when instructing a vendor. Remember that the obligation is ongoing. It's not just when you're thinking about instructing a vendor. It's also required throughout the contractual relationship. And make sure you maintain evidence of any due diligence that you've carried out at the start or throughout your relationship with that vendor. So we've now explained how to recognise the various vendor relationships, the importance of due diligence and how you can explain this to others, and how you can explain to others how to carry out due diligence and how to evidence sufficient guarantees. This brings us to the end of the fourth module of 2A of Fieldfisher's Get Data Protection Fit programme, putting data protection into practice. Here are our contact details should you wish to get in contact with us regarding any of the points raised in this session. Thank you very much for listening.